Hello, and welcome to Williams Mullen's Trending Now, an IP podcast, a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets such as patents, trademarks, copyrights, and trade secrets. I'm your host, Janet Cho, and today we'll be discussing whether or not there are currently any trademarks available and what you should do about it. So my topic today was inspired by a client of mine, actually. This is a couple of years ago now, and we were talking about a trademark issue the client had, and he said out of frustration, jokingly, I sort of feel like there are no trademarks available. Isn't that kind of crazy? And we both had a good laugh about it, and we just kind of left it there. However, as many of you all as listeners may have found out, this subject has actually been the subject of a lot of discussion and even the subject of empirical study. So it's not just, if we've all been joking about it up until now, it's actually become a fairly serious topic. And it's a big topic, so I won't cover all of the complexity, but really just some of the highlights about this feeling or this notion about whether or not trademarks are there any trademarks available, and what are some things that you can do to deal with the landscape of feeling or encountering the situation where you feel like the trademark you're interested in and maybe perhaps your second, third, fourth, or fifth choice is not available. So what do we mean when we say, are there any trademarks available? Because technically, given all of the words available in English and, perhaps associated other languages, the supply of trademarks should technically be inexhaustible. But we have recently over the past few years, I would say, faced the situation of trademark depletion and trademark congestion. And those are two related but different concepts. So trademark depletion is the phenomenon where you essentially have fewer and fewer marks that are unclaimed by anyone as owners. So the flip side of that is there's basically fewer and fewer marks available for use and registration because an increasing number of trademarks are already claimed to be owned by someone. And just to support, this depletion argument, because I think a lot of times when we talk about this subject, it's again a feeling, but we can't really point to anything concrete as to really, our trademarks really being depleted. Just recently, the United States Patent and Trademark Office came out with some facts to support this, depletion. So the way I look at it is if the USPTO is talking about it, it's definitely a legitimate phenomenon. And some of the facts they recently released are that since June 17th of last year, there's been a 63% increase in new trademark applications that have been filed. So generally, there's been a surge in new applications. And since this time last year, it's gone up 63%, with 211,000 more applications having been filed between this time last year and now. Since December 2020 and December 2019, there's actually been a 172% increase in applications. And the increased number of applications have been filed by domestic applicants as well as applicants based abroad. I've heard from a lot of clients and other practitioners where the thought is that the increase in the number of filings is primarily due to applicants based abroad. And that is part of it. There's certainly been an increase in foreign filers, but there's also been a concomitant increase in domestic filings or applicants based here in the United States. And part of the reason for the increase both domestically and internationally in terms of applicants is that during COVID, there has been a substantial increase in e-commerce. So everybody wants to file a trademark application for their e-commerce business. And how that plays out, just to give you some examples, because in terms of just discussing depletion as maybe sometimes people have called it maybe just an urban myth or a myth among practitioners, but it has had some real world consequences. So one thing I will point out is that there are many industries or many segments of commerce, including, say, craft beer, cosmetics, musical groups that have basically found that the marks that they're looking to use or register are off limits to them. And that's partly because industries or businesses in these realms are generally capitalizing on maybe the same themes or the same commercial evocations. So things like city names, landscape names, natural features, a lot of these names and designations are already registered. So they may be off limits to you, at least for a particular segment of goods and services. Also, a very large proportion of surnames are already registered. So you can kind of see that if you are looking to create a particular connotation with a mark based on, say, a geographic place or some natural place of beauty, because you really want your beer, your drink, or your clothing company to evoke that, you may be precluded because at least one other party and perhaps others have filed to register or have registered that mark. So you may find that your best idea for a mark is not available. And so you're going to have to seek an alternate ground and choose perhaps your substitute mark or your third or fourth best mark, which is, I think, in all of this, when it comes to depletion, something that's very much a concern to a brand owner, because typically your brand is meant to evoke who you are and what you do. And very often there's not a lot of ways to convey that. There's really just one unique and specific way to convey that about your business. So if that word or that phrase or that slogan is taken, it can definitely be an issue. So one thing I would point out from the get-go is, going into mark selection, if you are a new business looking to select a mark, or you're an established business and you want to choose a mark for a new product or service, is to, given the landscape, try and maintain some flexibility with the understanding that perhaps what you're looking for as your first choice of mark is not available. So going hand in hand with trademark depletion, there's also what's known as trademark congestion, which is similar to depletion, but it's the phenomenon where there is more than one party claiming rights to a particular mark. And generally under trademark law, that's permissible. So the example I like to give is there is the mark Delta for faucets, and then there is the mark Delta for airlines. And under trademark law, marks that are identical but that promote different goods or services are permitted to coexist. There isn't confusion. The issue with congestion is that, whereas faucets may be on one end of a product and services spectrum and airlines are on the other spectrum, because you have more and more people claiming ownership to, say, Delta or whatever the mark is, that continuum is becoming more and more crowded. So you may start to have people who have filed to register for or have registered, maybe not for faucets, but for plumbing services. And then we get into, home improvement. And then we get into, software that is used for a whole host of businesses, including but not limited to airlines. So you can kind of see with congestion, the continuum of goods and services that a mark might be available for is becoming increasingly crowded, and you're sort of slicing rights in a mark in terms of your goods and services more narrowly. The way I like to conceive of it is perhaps as an onion, where you are peeling off layers as an individual party claims rights in a mark for a particular good or service. Or if you have a, big long stick of wood and you chop off sections pertaining to what a party is already filed for or registered for, that stick becomes smaller and smaller as you chop off more pieces. So that's another issue with congestion, is that, what you may have previously thought as having some maneuvering room in terms of a mark that someone else has filed for or registered for, you may not have that maneuvering room with that mark anymore, depending on what your goods and services are. So with all of that, what are some things to consider? Well, I think, as I've stated, definitely come into the trademark selection process with some flexibility. That's not to say, I'm definitely saying be prepared to be disappointed, but when you are doing your mark clearance or your mark consideration, it might be helpful to have more than one mark that you're considering, perhaps one or two, or I know some parties even have a whole library of marks that they may be considering, and they let the diligence process guide what mark is going to be the most acceptable for them. Also, be prepared for increased pendency times when it comes to filing an application. With the increase in trademark application filings at the USPTO, there's so much more effort and resources diverted into examining those applications, dealing with office actions, perhaps even board proceedings that arise with those applications. So you want to factor into at least your application filing time an increased weight in terms of having your application progress. Now, that may lead to some corresponding business choices. So if typically you've had your marks register in a certain set amount of time or a more predictable amount of time, and that had some sort of business implication, you may want to, going forward, think about increasing those pendency times as they pertain to whatever you want to do or need to do with your business. You may also need to be prepared to invest some more with your diligence. If you are typically a party that always does diligence before adopting a new mark or filing a new mark, and your diligence has been relatively straightforward, you may find that going forward, your diligence is a little bit more nebulous. And so you have to perhaps spend a little bit more time digging into facts and say your search report, just to make sure that you clearly understand the landscape of risk. And also just making sure that you prepare your business launch around the fact that perhaps what you've chosen is not as distinctive as you thought. You may be entering into a marketplace where, initially you thought you were going to be the only party with this wonderful mark, but it turns out that you are actually, one of many parties. And perhaps these other parties are not doing what you do, and you're okay with that, but you may find yourself being not as distinctive as you initially thought. So, there are a whole host of considerations when it comes to this new landscape. But one thing I would definitely recommend is to give yourself as much time and consideration when you are selecting a mark, doing your diligence for a mark, and filing for a mark, just so that you can be prepared for the outcomes that may occur given this new landscape. I think one of the things that's probably come up a lot for clients of mine is there's increased unpredictability in terms of timing, in terms of, rejections you might get. So you just have to be as flexible as you can be, and be as open as you can be to perhaps changing course if necessary, depending on, what happens once you start using your mark or filing an application for a mark. So that will wrap up our discussion on trademark availability and what you should do about it. If you have any questions or suggestions for future episodes, please contact us. You can also visit our intellectual property practice page at williamsmullen.com/IP. There you can find out more about our team, as well as past episodes of this podcast and legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening, and until next time.